Welcome to this explainer. Okay, today we are setting out to demystify something that is absolutely foundational to our society, but let's be real, it's largely unseen by the average person until they actually need it. We're talking about the ethical standards of the Canadian legal profession. Think about it for a second. When you hire a lawyer, you are often at your most vulnerable, right? You're handing over your secrets, your hard-earned money, your business, or sometimes literally your freedom. So what actually guarantees that the person sitting across the desk from you is going to act in your best interest? Well, that's exactly what we're going to explore today. We are going to look at the bedrock rules that hold the legal profession together, and more importantly, how those timeless rules are constantly adapting to our fast-paced, rapidly changing world.
Here's a quick look at our roadmap. We'll start with Section 1, the rule of law. Then, we'll unpack some key legal definitions in Section 2. Next, we'll examine the pillar of integrity in Section 3, and we'll wrap the whole thing up with a modern standard of competence in Section 4.
Now, take a look at this. This is the official branding of the Federation of Law Societies of Canada. What we are digging into today is their Model Code of Professional Conduct, specifically the version that was just updated in April 2024. And listen, this isn't just a list of polite suggestions, not at all. This document represents the national baseline. It sets the absolute minimum expectations for lawyers nationwide. It's a highly instructive guide that acts as, well, basically the very DNA of Canadian legal practice. If a lawyer fails to meet these standards, they are risking serious disciplinary action for professional misconduct.
All right, let's jump straight into Section 1, the rule of law.
You know, lawyers aren't just hired guns. They actually hold a really unique, privileged position in society. And because of that, they're granted the power of self-regulation. But here's the catch. They have to exercise those powers in the public interest. They are active, essential participants in a justice system that advances the rule of law. In fact, the very preface of the Model Code explicitly states, one of the hallmarks of a free and democratic society is the rule of law. This goes way beyond just, winning a lawsuit. Whether it's the sale of a house, finalizing international trade, or a criminal prosecution, every single legal activity relies heavily on this concept. The public is relying on the integrity of the people working within this system. Because if the folks interpreting and challenging the law aren't fundamentally ethical, the whole system crumbles. The stakes literally could not be higher.
Moving right along to Section 2, unpacking legal definitions. First up, let's talk about what a client actually is. You might think a client is only someone who has signed a massive 10-page contract and handed over a hefty retainer fee. But actually, scratch that. The definition of a client includes a person who consults a lawyer and reasonably concludes the lawyer has agreed to render legal services. That's right, a formal contract isn't always needed. If someone sits down with a lawyer, shares their problem, and based on that conversation reasonably expects that the lawyer is now acting on their behalf, well, a lawyer-client relationship might have just been born. It's an incredibly protective definition for you, the public.
Next up, let's look at a conflict of interest. The code defines this as a substantial risk that a lawyer's loyalty to or representation of a client would be materially and adversely affected by the lawyer's own interest or the lawyer's duties to another. So the key word here, loyalty. Loyalty to the client is absolutely paramount. The Law Society is going to step in whenever a lawyer's personal life, their financial interests, or their duties to a completely different client create a substantial risk that they can't be 100% loyal to you.
Okay, Section 3, the pillar of integrity.
We've talked about the rules and definitions, but now we're hitting the bedrock. Integrity is described in the code as the absolute fundamental quality of any person who seeks to practice law. Now, we all naturally want to separate our professional practice from our private life, right? But for a lawyer, those two spheres actually overlap quite a bit. Questionable or dishonorable conduct in either sphere reflects adversely on the entire profession. Now, to be clear, regulators aren't trying to micromanage a lawyer's purely private hobbies. But if a lawyer engages in private conduct that is so bad it destroys public confidence or impairs a client's trust in them, the Law Society is absolutely justified in taking disciplinary action. You simply cannot be a trusted officer of the court from 9 to 5 and a fundamentally dishonest person on the weekends. It just doesn't work that way.
And that brings us to Section 4, the standard of competence.
So, we've covered honesty and integrity, but what should you practically expect when you actually hire a lawyer? The Model Code has a really broad and specific definition of what competence means. You are entitled to assume that your lawyer possesses a diverse toolkit of skills. We're talking legal research, deep analysis, precise writing and drafting, sharp negotiation,
effective advocacy, and creative problem-solving. Competence involves way more than just rote memorization of legal principles. It's the ability to investigate the facts, figure out what your actual objectives are, and then implement a chosen course of action using all of these specific skills effectively and cost-efficiently.
But, this kind of logically brings up a rhetorical question, doesn't it? What happens if a lawyer lacks competence for a specific task? Because, let's face it, no one knows everything. What if your family lawyer suddenly gets asked to handle a highly complex international tax merger? How does the ethical code handle a lawyer who suddenly realizes they are in way over their head?
Well, the code lays out 3 exact steps. First, the lawyer must recognize the limitation. They have to be self-aware enough to know what they don't know. Second, they can take the case, but only if they can become competent without undue delay, risk, or expense to the client. And third, if they can't manage that, they must decline the task. A lawyer has to be completely honest with the client and prioritize the client's safety and well-being over just taking a job to earn a quick fee. Proceeding on any other basis is considered fundamentally dishonest.
Now, here's where we get a modern twist. The April 2024 amendments force these ancient rules of justice to adapt to the digital age. Technological competence is now explicitly a required standard. A lawyer must develop an understanding of and the ability to use technology that's relevant to their practice. They have to understand the benefits and, critically, the risks associated with their software, especially when it comes to their absolute duty to protect your confidential information.
But importantly, the code is also highly practical about this. Technological competence isn't just one rigid, one-size-fits-all rule. It depends entirely on what is reasonably available, based on specific factors, like a lawyer's practice areas, their geographic location, and the unique requirements of their clients. For example, a lawyer practicing complex corporate litigation in a major downtown tech hub might be expected to use totally different technological safeguards than a rural lawyer doing basic real estate transactions. The rule is designed to be completely responsive to the actual environment the lawyer works in.
So, zooming out for a second, what is the ultimate goal of all these pages of rules, definitions, and standards? The preface kind of hits the nail on the head regarding the core philosophy. Rules of conduct should assist, not hinder, in a way that ensures the public interest is protected. This should honestly give you, the viewer, a real sense of security. The legal profession's self-regulation isn't about protecting lawyers. It's a framework built entirely around protecting the public, ensuring that anyone practicing law does so with competence, honesty, and unwavering loyalty to you. As we wrap up this explainer, I really want to leave you with a provocative thought to chew on. We've seen how the 2024 amendments introduced technological competence to deal with the digital age. But as artificial intelligence and brand new technologies continue to spread like wildfire, what new skills will your lawyer need tomorrow to adequately protect your rights today? How will this timeless bedrock of legal ethics continue to adapt to our ever-changing world? It's a fascinating question for sure, and one that the legal profession has to continuously answer to keep your trust. Thanks so much for joining me on this deep dive.